All right. That sounds better. All right, are we ready to get started? Everyone feeling awake? Got some snacks? Great. So this lecture is designed for those agents who have been BAP agents for less than 3 years. Does everyone fall into that category? Great. If you don't, there is a roundtable discussion upstairs for BAP agents who have been agents for more than 3 years. So, all right, wonderful. Well, it is my pleasure to introduce Kelly Larson. She is an assistant attorney general with the AG's office, and she provides us with a lot of legal counsel on our BAP cases and also works closely with PACFA. So everyone please welcome Kelly Larson.
Do you want to hold or stand? Let's just put it in there, I think. Okay. We'll try and, if you can't hear me, let me know. Is it okay? I'm hoping not to have to hold that. So good morning, everybody. Thank you, Claire. She said my name is Kelly Larson, and I'm counsel for the department. So I do a lot of different animal welfare issues. I do a lot of work with BAP and a lot of work with PACFA. So there's a fair amount of overlap. Do you need the microphone? It is a little far. Okay. Is that better? Okay, good. Okay. So I just spoke briefly with Claire before we started, and she mentioned that this presentation last year there were some hecklers because I think some of the hypotheticals or scenarios have been reworked for a couple years in a row now. So I was telling her, my hope is that this presentation, first of all, I don't get heckled, but second of all, that it is informative and helpful. The good news and bad news about your authorities and the scope of what you can and cannot do is that it's pretty specific. It's pretty, I won't say narrow, but it's very specific. So it's either in statute in Article 42 or in the rules. And the rules, frankly, mirror the statute. So really what we're looking at here is just the statute. That's good news and bad news. The good news is there's not a lot of room for ambiguity, or certainly less room for ambiguity. The bad news is it doesn't really make for a creative presentation. I'm afraid this presentation year after year will be more or less the same thing. So I'm going to try and mix it up a little bit, but my hope is that you all raise your hand and throw out different questions or ideas, especially when we kind of get to the hypothetical, so that you all get what you need as far as your training, and that this is actually helpful for you. So the first issue that we want to talk about is the purpose of the Animal Protection Act. We find that in the legislative declaration, which is where the General Assembly has opined as to what they want the act to actually do. The General Assembly hereby finds and declares that the protection of companion animals and livestock is a matter of statewide concern, and that the policy of the state is that persons responsible for the care or custody of such animals be persons that are fit to adequately provide for the health and well-being. So the intention of the act is both protection of companion animals and livestock, and that those who are responsible for their care are fit to do so. The legal standard is to inform this and to ensure that no animal is mistreated or neglected or abandoned in any circumstance so that the animal's life or health is endangered. There are 5 distinct categories of agents. There are those who work for a nonprofit, a municipality, law enforcement, and then the Department of Agriculture. Each of these categories is represented by someone in attendance today, and each of these categories has unique limitations as to its authority. The authorities, the express authorities of commissioned agents that can be conducted without law enforcement or the assistance of the department include civil investigations, cruelty investigations for misdemeanors but not felonies, the providing of adequate food and water to confined animals, and intervening to prevent mistreatment neglect, or abandonment, or cruelty. And in very limited or specific circumstances, which we'll get into in a little bit, cause euthanasia. All of these authorities come from Article 42 in statute, and then also Part 2 of the rules. But like I said, those rules mirror the statute as they should. Of these 5 different authorities, I believe yesterday the presentation with Tara Buckhalter covered misdemeanor cruelty investigations. So our discussion today is going to focus really on the other 4. Your first authorized activity is to conduct civil investigations. The goal or purpose of your investigation is to gather facts and evidence to determine whether a probable cause exists, often referred to as just PC. In the criminal context, we always operate with the understanding that everyone is innocent until and unless proven guilty. And similarly here in civil investigations, we operate with the understanding that no one has committed a violation of the act unless and until the evidence proves otherwise. So as you can see on the screen, your abilities or the process that you would go through during an investigation includes interviewing witnesses, making observations, which can be include what you see, what you smell, what you hear. I mean, we had a case, it was a couple weeks ago, I think, and I think it was Dr. Vaden was observing an animal and could smell what she opined and knew from her training and expertise was an indication of an infection or tissue that was needing, let's say, veterinary care. So be mindful when you're making observations that that can come in any form. Taking photographs, it could include taking video, body cameras, etc. You want to document your findings in a report. And then there's also the ability to get administrative search warrants with the help of either law enforcement or CDA. Remember that not all agents are authorized to investigate livestock. For those of you who are not CDA employees or sheriffs, or an appointee of a sheriff's office, within your own jurisdiction, you may not investigate cases involving livestock. Not everything that you do is going to fall under the title of investigations, and we'll discuss this in the context of food and water next. So except as authorized by law, no animal, and it's important we put the emphasis on animal as opposed to a companion animal or a livestock animal, shall be confined without an adequate supply of food and water. So all agents, regardless of where you work, can provide food and water to any animal found to be without adequate food and water. Again, the statute reads animal, which is very, very broadly defined in statute as any living, dumb creature. So entry may not be made into a building that is a person's residence without a search warrant or court order. And notice of entry and care shall be given by posting such upon an area or building where such animal is confined. So be very mindful of what you are entering. It can sometimes be not clear. Some buildings, outbuildings, barns can actually be used as a residence or have a multifunction purpose. And in the case of companion animals, 72 hours without food or water by anyone other than an agent, vet, peace officer constitutes abandonment, abandonment is a violation of the law. That's in statute 3542-109, and permits you to issue a criminal summons and complaint for misdemeanor animal cruelty, and or to engage law enforcement, and or to refer the case to the BAP program manager. These options are not exclusive, so you can do any one of them, or you can do all of them, or a limited combination of them. You can also lawfully intervene to prevent mistreatment, neglect, abandonment, or cruelty. This is a tricky one, however. It's very difficult to lawfully intervene without subjecting yourself, first of all, to harm, potentially, or without engaging in an action that exceeds your statutory authority. You all don't have the authority to take an animal or arrest a person. You may or may not be armed, but again, the goal should be to prevent harm and, frankly, de-escalate the situation to the best of your ability. Your options in each case are going to be uniquely specific to the facts that you're dealing with, but you do lawfully have the ability to intervene to prevent the perpetuation of mistreatment, neglect, abandonment, or cruelty, which occurs in your presence. And finally, you do have the ability to effect euthanasia. Any agent or peace officer may lawfully euthanize or cause to be euthanized any animal in his or her charge, when in the judgment of such agent or peace officer, and in the opinion of a licensed vet, the animal is experiencing extreme pain or suffering, or is severely injured past recovery, severely disabled or diseased past recovery. The statute goes on to talk about if a vet is not available and what steps can be taken. The animal can still be euthanized if, by the written certificate of 2 persons, and one of whom may be selected by an owner, if the owner so requests, views the animal in the presence of the agent, and the animal appears to be severely injured, diseased, or disabled past recovery. This is a really specific circumstance and a really specific set of facts. So the real takeaway here, or the main issue with euthanasia, is that the best practice is to leave this to the experts. If for some reason the facts absolutely dictate that you must euthanize an animal, make sure that you follow the statutory instructions provided in that previous slide. It's also best practice to ensure that you let the Department of Agriculture know immediately or as soon as possible that it has happened. Has anybody had a case where they've had to euthanize an animal in the field? You have? Are you comfortable telling us about it? And you wouldn't necessarily need to include a name or any specifics, but...
Yeah, I can talk vaguely about it. It was a dangerous dog case, and the cops had to shoot the dog. The dog didn't die. Like, they shot him in the skull, but he wasn't really dead yet, so I just assisted with the euthanasia solution.
Okay, so you injected it. I'm sorry, the owner was president?
Yeah.
Was president? Okay, so you injected the solution?
Yep.
Yeah. And that's really why, there are so many safeguards in relation to this topic, because what you really don't want to have happen is that you shoot an animal and they don't die. Yeah. And you end up perpetuating potentially additional suffering. Was the owner...
The owner was actually attacked by their own dog.
Oh.
It was pretty severe.
Wow.
Yeah.
Okay. Thank you. So here's the dreaded hypothetical, which, like I said, in years past, we've been heckled by. So the hypothetical is that an anonymous complaint comes in with the following information. There are sheep in Grand County that have been confined in dangerous enclosures. They are too small. They don't allow the animal to turn around, lie down, or otherwise engage in species-appropriate behaviors. There's no shelter from the elements. Let's say it's winter up in Grand County. No food, no water. So the program manager asks a BAP agent that is employed by a nonprofit agency to drive to Grand County and do an investigation. So the question for you all is, can the BAP agent do that? So what's really relevant here and needs to be highlighted is that we're talking about sheep. Are they livestock or companion animals? And it can vary. Sheep do meet the definition of livestock. We have an allegation of inappropriate enclosures. We have an allegation that there isn't food or water. And be mindful that your ability to enter and provide care, specifically food and water, is not limited just to livestock or companion animals. It's to all animals. Also, highly relevant here is that the BAP agent is employed by a non-profit entity. Livestock is defined in statute. I think it might be in Rule 2, but it's definitely in statute, 3542-102, used in the farm or ranch production of food, fiber, or other products defined by the commissioner as ag products. There is a list of animals as well under the definition, and sheep is expressly included. So whether or not the BAP agent can investigate really comes down to a question of what is the purpose of the trip or the reason to go to the property in Grand County. You would not have the authority to simply investigate a cruelty allegation when it comes to livestock if you are employed by a nonprofit. However, in this case, there's an argument that we are not investigating livestock. You're going out to check for food and water, not to check on the enclosures or the lack of shelter. And any agent can do that for any animal. So what happens if you go and you provide the food and water, but you also observe that the enclosures are a problem and that it amounts to a violation under 109 or amounts to mistreatment and or neglect to such a degree that it is endangering the life or health of the animal. Your ability to make observations, like for example, that the enclosures are too small or are dangerous, can contribute to probable cause. So it's still highly relevant. You can still and should make observations and document your findings, but you are not able to actually investigate a finding of cruelty as a result of those enclosures, lack of shelter, or really anything else that you find not related to providing food and water. Are you all familiar with the plain view doctrine? I see some heads nodding, so I will assume that you are. What happens if the agent finds the sheep to have had food and water, but in the process of going onto the property or leaving the property sees that there are chickens nearby, clearly in distress and without food and water? You can provide those chickens with food and water and do what you need to do to ensure that they have what they need. If you find evidence of another crime or another type of violation, you are similarly limited in your ability to investigate that. But again, your observations can amount to probable cause and can be used in somebody else's investigation. So you want to make sure you document and keep your ears and eyes open to observe as best you can. In the process of providing food and water, if you observe potentially another issue related to not having food and water, like the chickens, you can provide it. If, for example, you have evidence of an animal that maybe it's a little more attenuated, so you cannot actually see, for example, the chickens, or in this scenario, you hear an animal kicking a stock tank, and in your experience and training, you know that indicates that the animal is without water. What are you able to do? What are your authorities? Let's say it's in a nearby barn, so you can't actually see what's happening. All you can do is hear it. But again, based on your training, you know what the significance of that is. The question is, are you doing any of these things to collect evidence related to an investigation of cruelty, or are you there to do something else? this is, like I said, this is tricky. I think your fallback here is, of course, to get a warrant. That's the safest thing. Engage law enforcement so that you're not exposed, and don't run the risk of gambling as to whether or not it's a residence. As I mentioned earlier, a lot of these outbuildings, it's not entirely clear until you get in that somebody's in fact living in there. Are there windows that you can peek in? Are there cracks in the wood? Can you get close enough to listen? If there's a gate between you and the barn, you cannot enter that gate. No trespassing signs. You need to be very mindful of that. But any evidence that you can collect, or any facts that you can collect that indicate whether or not it's a residence, is helpful. Generally speaking, you're not going to want to gamble on that, and you should just get a warrant and employ law enforcement. But if you are able to see through an open window that there is in fact an animal in there, and that animal is without food and or water, you could enter at that time. And be mindful that you may not want to enter. I mean, again, safety is of paramount importance. The best practice here is probably to get a warrant and engage law enforcement. The commissioner has authority to make any investigation necessary to ensure compliance with the act, and the commissioner shall have free and unimpeded access upon consent or upon obtaining a search warrant to buildings, yards, pens, pastures, and other areas in which animals may be kept. But keep in mind that it shall be lawful for any agent of the Bureau to enter into any area or building where such animal is confined and supply it with adequate food and water, with a limitation that it shall not include building entrance into any building which is a person's residence, unless you in fact have a search warrant or a court order. So this hypothetical goes on. The agent does in fact enter the barn. It's not a residence. There are sheep confined in the barn. They don't have access to food and water. They appear severely emaciated, and one has an injured leg. At this point, the agent, again, can provide the food and water and take steps to accomplish that, but cannot investigate the cruelty. So cannot do much more to investigate why these animals are emaciated and or the injury. Again, your mental notes and impressions are very important. Not related necessarily to an investigation, but you can establish probable cause and thereafter assist law enforcement in their investigation. And you all have an expertise in training that they may or may not have. It can be very helpful to include your mental notes and impressions. You can take pictures, and you can certainly write those notes down and provide them to law enforcement or to whoever party is investigating the cruelty. Again, engage local law enforcement and call the BAP program manager. You do not have the ability to touch the animal. This can be kind of a gray area. I mean, if you're needing to put down a bucket with feed or water in it and move the animal to the side, and in that process you can feel bony prominences, that's something that you should document. But within reason. There is, this can be a slippery slope. There are times, again, if you smell something, if you hear something, if you have a need to touch an animal, but you cannot, if it's confined in some way or tied up, you can't untie it, you can't open the gate to its pen, and you certainly can't remove it from the barn, which could be very difficult, especially if the animal is suffering right in front of you. We had a situation recently in which we had a agent go out on entry and care, so to provide food and water. It was very remote, very rural. So the question is, how do we go back out now, get the food and bring it back? And there was a question as to whether or not maybe there was food on site or food on scene. And so could you look around in the barn? Could you open some cabinets? And there was a wagon that was covered with a tarp. It kind of smelled like hay. They presumed that was probably hay in there. And all that agent needed to do was lift up the tarp, pull the hay out, give it to the animals. Can't do it, not without a warrant. So my advice to that particular agent was, you're gonna have to leave, go get feed, and come back, which I know is not convenient, but it is the safest thing to do. So again, this is kind of tricky. You need to be very mindful of your changing role and that you really are limited to what you can and cannot do to provide just food and water. So you would not write the report or actually collect any of the evidence. You don't want to touch anything, but make a mental note of what is relevant or what will be helpful for law enforcement. They may or may not know. I imagine that their level of expertise varies significantly, so you could be very helpful in terms of telling them what evidence to take, what will be relevant. Should they take samples of feed? What should they photograph? How do you transport and load some of these animals, especially if there's been an injury? And how do you can certainly assist in engaging veterinary assistance. So finding a veterinarian and helping to bring him or her up to speed on the case. And always, your observations still form the basis of probable cause, or PC. Civil and criminal cases have a lot of similarities and a few key differences. Both provide for complete investigations and warrant authority. So in both cases, you can get a warrant to enter buildings and do more thorough investigations if you need to. In my opinion, a civil case has more options early on in a situation. So you have the ability to issue, with the commissioner's assistance, a cease and desist order and or obtain injunctive relief. So if somebody is clearly not doing what they need to do to ensure an animal is not being mistreated or neglected, oftentimes a cease and desist order or an injunction takes care of the matter. It's a way of essentially giving that animal owner another opportunity to get it right or to become compliant before criminal action is taken. It can be a very useful tool. Both criminal and civil authorities have the ability to remove animals, although it's done quite differently in each case. A civil case requires a prompt hearing on fitness, and a criminal case requires a prompt hearing on cost of care and probable cause. The remedies can also be really similar. I found that it's easier to customize remedies in a civil matter. We, generally speaking, will draft or at least provide the court with a proposed draft of an injunction, and we can include more terms or more limitations. So it's not unusual for us to say, you're permanently enjoined from owning an animal with a body condition score of less than 4, or not getting farrier care or teeth floated. I mean, these can be really specific examples. That's usually not something that you see in a criminal court. There's also going to be less oversight in the end in a criminal court. Generally speaking, after a conviction and a sentence, it's done. The defendant may have probation or somebody to answer to, but it's certainly not going to be the specialized kind of oversight that you might get in a civil case. So if a cease and desist order is in effect or an injunction is in effect, law enforcement or BAP agents that they're after go out and find additional or ongoing violations are going to have a heavier hammer and are frankly going to be able to act much more quickly. Something else to consider between civil and criminal cases is that if you have a situation where somebody is likely to repeat the behavior, or you're likely to have ongoing situations, a criminal case will have a much more effective hammer or a much more effective ability to document and track this individual. So a criminal conviction follows an individual through every state and forever. A civil remedy or a civil consequence, that's not the case. Generally speaking, it's limited to the state of Colorado. It can be even more narrow than that. And there is no record. So if they move out of state and continue the behavior, that new state can't easily look up and find out that it's happened before in Colorado. So something to consider when you're making a decision as to whether or not to pursue a civil remedy or a criminal remedy, or both. When it comes to a livestock action, what's important to note is that even the commissioner has no authority to take livestock. The commissioner has to petition a court for authority to take livestock before she does so. This is the court acting to ensure that reasonable grounds exist to establish that livestock are being mistreated, neglected, or abandoned in any circumstance, such that their life or health is endangered. The statute does require a prompt hearing, and the purpose of that is to provide timely due process. A lot of similarities as to what authorities exist for companion animals. The only difference for companion animals is that the commissioner does not need an order of the court. The commissioner can make the determination to remove the animals. They can also work with PACFA and community resources as needed without a court order. What triggers a court hearing? Anytime the commissioner deprives a person of property. Animals are property. They have value. So at the time of a hearing to determine an owner's fitness, the court must answer really two questions. Is the person able to adequately provide for the animal? And is the person fit to own the animal? At the hearing, the court makes absolutely no determination as to any other animals that person owns, either on that property or elsewhere. Also makes no determination about future ownership. So the only question is whether the owner can own and take care of that specific animal. So there are times when we're talking about 2 or 3 animals, and then there are times when we're talking about hundreds. It can vary widely. So what needs to be proven, whether somebody can adequately provide for the animal? Is there a lack of feed, lack of water, lack of shelter? Animals actually dying or dead from starvation or dehydration. We see this a lot. Well, not really this time of year, I guess earlier spring, when there's just not enough forage or not enough pasture land for animals, and they're not being supplemented for whatever reason. It can also include lack of ordinary veterinary care. The next element to prove is whether or not somebody is fit to own. Are they capable of understanding the needs of the species? Are there consistent examples of ongoing mistreatment, neglect, or abandonment? And is there some sort of mental or physical infirmity? Civil enforcement options, like we said, included a cease and desist order. The purpose is to provide an individual with notice that they must cease and desist from committing or failing to perform any action that violates the act. There is no requirement that there be a hearing beforehand. We simply issue the cease and desist order. We have control as to what it says and how it is drafted. It does not require a trial. It doesn't involve state court at all. Somebody can challenge a cease and desist order. Once it's issued, they can challenge it, and that there would be a hearing related to that. That's in the Office of Administrative Courts, as opposed to state courts. It is permanent in nature. Before issuing a cease and desist order, we have to establish that we have reasonable cause to believe that a violation has occurred. That's a pretty low burden. So reasonable cause can be based on hearsay, for example. You may or may not have observed it yourself, but as long as there is a witness who has seen it, pictures of it, so even if you haven't seen it with your own eyes, but there's pictures of it or video coverage of it, that can be sufficient. It does require immediate enforcement. It usually gives about 24 hours for somebody to become compliant. It depends a little bit, too, on what it is. Certain things, by their very nature, are going to require more time or more than 24 hours. And ultimately, it orders a person to cease or stop doing something, violating any provision of the act. What we have to establish in the cease and desist order is that and list the act or acts that are alleged to have been violated, what statute has been violated, or what provisions have been violated, and then we also will require that all action that's resulting in the violation be ceased. As I said, CDO is permanent in nature. It does stay on the books forever, although it can be withdrawn. I don't think, to my knowledge, that's ever happened. I'm not sure why we would ever withdraw one. As I mentioned, it does trigger a right to a hearing, but that's in administrative courts as opposed to the state courts. If there is not compliance within that first 24 hours, and again, being mindful that some actions cannot cease within 24, it may take a little more time. If the actions do not cease when they should cease, we can take additional legal action. Usually that looks like injunctive relief, not always, but usually that looks like a temporary restraining order or injunctive relief. Injunctive relief is, just like it sounds, an injunction or an order from the court. So it's coming from the judge this time, telling somebody to stop doing something or to do something affirmatively if need be. We require that it include evidence sufficient to the commissioner that a violation has occurred, that a person has engaged in or is about to engage in, which is really broad language. So it's not necessarily required that somebody has actually violated the law. It can just be that they are about to engage in the law. We would need significant amount of evidence to establish that they are about to as opposed to they actually have, but it is very broad, which is important to keep in mind. And it could be any act or practice that constitutes a violation of the act. The jurisdiction of the court is usually where the animals are located, where this person is located, where the actions that constitute the offense are occurring. Be mindful with injunctive relief and cease and desist orders too. It's only the commissioner who can exercise these abilities, and only the commissioner's counsel who can represent the commissioner in a court of law. So if you feel you have a situation where a cease and desist order or injunction would be beneficial, please reach out to the program. When we file for an injunction, the case starts with a temporary restraining order, which is just like it sounds. It's a temporary order from the court saying stop doing something or start doing something. Get compliant with the act. It's done ex parte, which means I file it, my office files it with the court, and the person against who it will be issued doesn't know. So normally when a case is filed, any legal action is taken, everybody's notified that it's happening. In this case, the animal owner will not know. It's done ex parte. It's also done on a very expedited basis. We usually get it the same day, or at the most, the next day, about 24 hours. Once we have it, we serve that on the animal owner. That's when they become aware of the case and the temporary restraining order. It does require immediate enforcement. Because it's ex parte and the other party was not involved and did not have an opportunity to be heard, it has a pretty short timeline. It usually only lasts for 14 days. That can be extended if the court finds good cause, but usually what needs to happen is that within that 14 days, it's set for a hearing on a preliminary injunction, which is the next step after a temporary restraining order. A preliminary injunction is an evidentiary hearing. So witnesses will be called, exhibits will be admitted. We have to actually prove the case at that point or prove that the violation has occurred. Generally speaking, it has to be, like I said, within that 14 days. And doing that within 14 days can be very difficult. Finding witnesses, interviewing witnesses, preparing the case, that's a very tight timeline. It's not unusual for someone to ask to continue that hearing for a preliminary injunction, and the courts usually grant that and will then extend the temporary restraining order past the 14 days. The judge can do that if he or she finds good cause. Again, the goal of the preliminary injunction is to put on the case to establish the violation. That preliminary injunction will then remain in effect. It usually looks exactly the same as the temporary restraining order, but it can go for much further. Again, because there has been a hearing, the defendant has had an opportunity to be heard, and the evidence reviewed, it can go much longer than 14 days. It usually will go all the way up until the final trial or final hearing on an injunction. And sometimes that's months, sometimes that's weeks. It really just depends. We also have the option to consolidate those into one, the preliminary and the permanent. Usually that's something that a defendant will challenge and try to stop. And it's usually something that we want to do just for the efficiency of judicial resources. The intention behind all of this is to maintain the status quo. So when you see a violation, you want it fixed and fixed immediately until and unless we can get in front of a judge and have the full hearing process, whether that be the preliminary injunction or the permanent injunction hearing. So the point of this is to really just maintain the status quo. Eventually, once we have the hearing on a permanent injunction, which is a full trial, it will enter. Both parties will have had the opportunity to provide all the evidence in support of their positions. The terms of a permanent injunction, if it's issued, are very specific. Usually we draft a proposed order so that the court has the specific details that we feel is appropriate. And as I mentioned, there's a lot more flexibility than there is, for example, in a criminal conviction, because we do have the ability to craft specific language or specific terms. And in fact, it really has to be specific. So we can't simply say to somebody or in an order that you have to comply with the act, that you have to do everything that is in the Bureau of Animal Protection Act. That is not sufficient or specific enough. We really need to get specific about feeding animals, providing veterinary care, or whatever the terms may be. So these, generally speaking, are the different remedies. These are not exclusive. They can work together. We can pick and choose in each individual case what is going to be most appropriate. As I mentioned, the commissioner can issue a cease and desist order almost immediately without taking further action. We do not need a court's involvement. And they can do that exclusively, just issue the cease and desist order, or they can do that with and part and parcel of a removal and a fitness determination, or part and parcel of an injunction. The Colorado Open Records Act, often referred to as CORA, is found in statute. It's declared to be the public policy of this state that all public records shall be open for inspection by any person at reasonable times. What is a record? It's extremely broad. It's defined as writing, all books, papers, maps, photographs, cards, tapes, recordings, or other documentary materials. So it's common sense tells you that it's a document that you've written, a report, an email, but it can also include audio recordings, video recordings, and things that maybe are not typically considered a document or a writing. Generally speaking, the most important question for you all is going to be what records are subject to CORA. A general overview of CORA is that any public business should be open to the public. So when you all are engaging in public business in the form of some sort of a document or writing, it can and should be held open to the public. And that's what you all should assume. There's a list of exceptions or times when we can redact or withhold information, either a document in its entirety or just parts of a document that we would essentially black out. There's a long list. The core statute is not short and not an easy read. You all should assume, however, that those exceptions likely don't apply to you. So anything that you put in writing, anything that is created as far as a recording or a document will be open to the public, can be viewed by anybody at any time. So assume that any records related to the Commissioner of Agriculture are open to the public. Any records related to the Bureau of Animal Protection are open to the public. Agents who are working for law enforcement are subject to something else, something additional, the Criminal Justice Records Act. So that's a little bit different, but you should still assume that it's all open to the public. Agents who are working for nonprofit entities are operating exclusively as the Commissioner of Agriculture, and so their records are subject to CORA. That means if you receive a request from a reporter or a requester that is just the public, it's not sufficient to say, the records are the property of an entity that is non-governmental, we don't have to turn them over. We do have to turn them over. Those records were established and maintained to fulfill the purposes of the Animal Protection Act. They are very much subject to CORA. So the best practice, again, is to assume everything that you have, everything that you create is open to the public. If you get any kind of a request or a question, please forward that request to the department. It's not always clear. These requests are supposed to be in writing, but you may get one out in the field. You may also get one via email or informally. When in doubt, forward it on, and we will help determine whether or not CORA applies and what needs to happen next. And it's really critical that you do this very quickly. We are subject to a very short timeline. It's generally 3 days, 3 business days, although again, because the statute is so comprehensive, there are exceptions to that. But for the purposes of this, you should always assume that we have a very tight turnaround. And that's not the time that you maybe open the email or the time that it makes its way to your desk. It's the time that it shows up that's initially sent. So again, please forward it immediately and directly to the department. I usually work with CDA to analyze a request, clarify it if necessary, which is often the case, and then thereafter direct delivery of the documents. Should there be any. Just another quick point to keep in mind is the dangerous dog registry. This is maintained at CDA after conviction of unlawful ownership. The convicted individual must permanently identify the dog by having a licensed vet or shelter implant a microchip. This is, generally speaking, a useful tool to check for reports or records of dangerous dogs in the state. Be aware, however, that it is not wholly comprehensive. It's just a starting point. It's not an end-all, be-all repository of information. Are there any questions? Or any areas that are not clear? Anything that you're seeing out in the field that you're hoping to get a little more guidance on? No? Okay. Well, thank you very much for your time.